Okay. Well, it's a couple of minutes and we have a pretty exciting and jam-packed session to give to you all today. So we might jump straight in and we will allow people to kind of filter in as they come. So welcome to our ACON's partnership with Dowson Turco and Advanced Care Planning Australia for our LGBTQ plus legal planning online workshop. Thank you everyone for joining us. So just to begin the workshop, I'd like to start us off with an acknowledgement of country. So I'd like to acknowledge the traditional owners and custodians of the lands on which we gather. I'm sure that we're all gathering from lots of different places around this country. I'm calling from Gadigal land of the Eora Nation, but please feel free to pop in the chat which lands you're dialing in from if you want to contribute that way. I'd pay my respects to elders past, present, and emerging, and any Aboriginal or Torres Strait Islander people joining us today. We recognise the continued connection to lands, waters, and skies of this country that the First Nations people have, and acknowledge that sovereignty was never ceded, always was and always will be Aboriginal land. So thank you again, everyone, for joining us. It's a pretty exciting turnout already, so we're really excited to jump straight into things. We have a pretty jam-packed session, like I said, so I'll go through everyone that is with us here today, do some introductions and then some housekeeping, and then we will jump right in. So firstly, my name is Zoe. I use she, her pronouns, and I'm the Community Health Promotion Officer for palliative and end-of-life care here at ACON. And we're also joined here today by Russ, one of our panelists, who he coordinates ACON's aging programs, including our Love Club, which stands for Living Older, Visibly and Engaged. So a few of you may have had any involvement with ACON in the past. This may be a few of your first times getting involved. So very special welcome. So we're an LGBTQ plus community health organization, and essentially we're committed to improving our community's health, including people living with HIV around New South Wales. So we're doing this in a number of ways, lots of ways through different programs and workshops. And Russ and I are really excited to share this through palliative care and end-of-life care. And we really want to normalize conversations around death, dying, and what it looks like to take control of these topics and prepare for them. So we're really excited to have this opportunity to share this legal workshop with you all. We think that this is one of those really important things, right? That we kind of know some of these words in the back of our minds, but lots of us may not know exactly what it looks like to be prepared for end of life in a legal sense. And our community is very fortunate that in a lot of ways we can be protected legally and our chosen families can be protected legally, but we also have to remember that we are, living in systems and structures that kind of assume that families and wills and end of life looks a certain way. And we know that our community doesn't always, fit that stereotyped way. So it's really important for us to be aware of how to legally protect ourselves, especially in the end of life scenarios. So we are so lucky to be joined by Dowson Turco and partnering with Dowson Turco. So wonderful Larissa Schreiber is going to be leading us through this workshop today. I'll let Larissa introduce herself properly a bit later on, but we also would like to welcome Kylie Ash as well from Advanced Care Planning Australia. So Kylie's going to be leading our second workshop, but we'll pop in at the end today as well to introduce herself briefly and say hi. So I'll just jump into some housekeeping. Firstly, just the way, as you can see on the screen here, the way that this workshop is going to run. We're going to kind of let Larissa go through her presentation and just give a big overview to all those key legal things that we need to know for end of life and palliative care. And then towards the end, we will have a chance for Larissa to describe some case studies and talk to some of the questions that were responded to in that enrollment survey. So thank you everyone who did that, who said what they were interested in learning about. There are some really interesting similarities with a lot of us, turns out, want to learn about the same things, which is great. So the questions will be picked out from what we heard from you all in the responses. But if there is something that is maybe missed in this presentation, it could be covered next week. And we also will have a bit of time to have those questions as well. Feel free to comment any more questions in the chat as well, and we can try get through them. But also, if you have any particular concerns and you would like to talk to one of the panelists, we will be staying back a little bit afterwards as well. So that's always an option also. Just a quick disclaimer as well, we are recording this session, so it will be a great opportunity for us to upload this later so that everyone can view it in your own time and take the messages in again. I don't know about you all, but I often need to rewatch something to really get it through my head. So we'll be uploading that to our ACON YouTube channel. But at the end of this workshop as well, we will be sending out some more resources that we kind of mentioned today, as well as an evaluation survey. So look, that kind of wraps up my introduction, and I might pass it straight along to Larissa. So Larissa, take it away.
Thank you, Zoe. Good evening. My name is Larissa Schreiber, and my pronouns are she, her, and I am a solicitor at Dowson Turco Lawyers. I grew up in South Africa before moving to Perth for my studies, and then adventured to Sydney to become qualified as a solicitor. In today's workshop, we are going to cover the topics of wills, their important considerations, powers of attorney documents, enduring guardian documents, and I will also briefly discuss healthcare directives, although that will be elaborated on in the next workshop. Please hold off on your questions until the end, as we have some designated time for them. Prior to working at Dowson Turco Lawyers, I worked in very traditional law firms. I saw firsthand how wills were often treated as simple and standardized documents: plug in some names, distribute some assets, and call it a day. These copy-paste wills were very quick and efficient for the firm, but completely inadequate for the people that they were meant to protect. And it wasn't until I started working at a more diverse firm with clients from very diverse backgrounds that I truly understood how flawed this approach was. Every family has its own unique circumstances: blended families, chosen families, cultural considerations, vulnerable beneficiaries, and sometimes very complex assets. And so a one-size-fits-all approach just simply doesn't account for the nuances that could make and break an estate plan. So before I discuss what is a will and why you need one, I'm going to touch on mental capacity. So to make any legally valid decision, it is very important that a person has the mental capacity to understand the nature and consequences of their choices. The test for capacity is from the Law Society, and it will depend on the type of legal decision being made. This could be signing a will, entering a contract, or appointing or changing who you've nominated as your attorney or guardian. Some of the things which may result in a lack of mental capacity are Alzheimer's, dementia, stroke, or just brain injury. These are unfortunately things which are part of old age. It's important to make sure that your estate planning is in order prior to mental capacity becoming an issue. Next slide, please, Zoe. So what is a will? A will is a legal document which protects your interests and assets. It will identify the executors, your administrators. It will account for all of your assets, and it'll clearly set out the beneficiaries of your estate. It can even include things such as your funeral directions, your preferences as to organ donation, and even a pet clause so that someone will look after your pets if you were to pass. Why do you need a will? You need a will to protect your assets. you can also avoid family disputes, and essentially you want to ensure that your money is being distributed as per your wishes. In New South Wales, if a person dies without having had a valid will, then their estate will be distributed as per the Succession Act, which is the legislation that governs this area of law. The Succession Act dictates that your estate is going to be distributed to your spouse. This will include your de facto spouse or same-sex spouse. However, if you don't have a spouse, then it will be distributed in the following order. First, to your children in equal shares. If you don't have children, then to your parents. If no parents, then to your siblings, followed by grandparents, aunts and uncles, and cousins, as opposed to your chosen family. There may be many relatives that you do not wish to benefit from your estate. You may also have had multiple spouses in your lifetime or significant de facto relationships, which may feel that they're entitled to a share of your estate. And they may be. The court will decide based on their contributions to your life. We had a client at our firm who had entered a marriage of convenience to assist his partner at the time with a visa. However, he never formally got divorced and had a de facto spouse since, which was a very important consideration for his will. Another case study I wish to share with you is a matter we had at Dowson Turco Lawyers. Our client, who I'll name John, was the de facto spouse of a deceased person, Michael, and they were in a relationship for 21 years. They lived together, they vacationed together, they lived their lives together. Unfortunately, Michael did not have a will. So when Michael unexpectedly died, John was meant, as his de facto spouse, to receive the entire estate. However, Michael's family denied that they were ever in a relationship and stated that they were merely housemates. The family then entered proceedings to try and take claim on Michael's estate and to take his money and property. There were then many issues which had resulted in obtaining an accurate death certificate to reflect our client as the rightful de facto spouse and next of kin. There were issues communicating with the superannuation companies, paying for the funeral costs. The legal costs to our client in defending such a claim without guarantee of success were also significant, and just extreme mental strain to our client when they were still trying to grieve the loss of their partner. Another important consideration to note, your superannuation does not form part of your estate. And the reason for this is because it is held in trust by the super fund. And so it is distributed according to that particular fund's rules and any nominations which you may have made. You may also wish to exclude people from your will. You may feel that a beneficiary, such as a sibling, has had sufficient provision made for them in their lifetime, and you don't wish for them to benefit from your estate. You may also feel that you may also wish to exclude someone because you've not had a relationship with them or spoken to them in a very long time. Perhaps it's a sibling that did not accept your sexual orientation, and so you feel that they should not benefit from your estate. You can also include pet clauses, as I previously mentioned, or funeral directions. I've had requests for non-traditional funerals and have used the words no funeral, no fuss, no flowers. On the contrary, I have also had written directions where clients have requested specific guest lists and even been very particular as to what kind of music they want played at their funeral. So it's important to communicate your wishes and preferences with your executor and to sit down and discuss this with them. Next slide, please, Zoe. What is a power of attorney? A power of attorney is a legal document in which you appoint a trusted person to manage your financial affairs. An example of this might be if you were traveling overseas and you needed somebody to pay your bills. Or you could be really unwell. So you could have lost mental capacity, in which case you'll need an enduring power of attorney. And then this person that you've nominated can manage your affairs when you're unable to do so. This differs from an enduring guardian in that an enduring guardian is a document where you appoint someone to make lifestyle, health, and medical related decisions. This could include dental treatment or the kinds of services that you would receive at home or in hospital. If you lose capacity and you have not appointed an enduring guardian, you may need to make an application to the New South Wales Civil and Administrative Tribunal to have a guardian appointed for you. A healthcare directive, sometimes referred to as an advanced care directive, is a document which outlines your wishes with respect to medical treatment. This could be resuscitation, how you feel about end of life care preferences, pain management, refusal of particular treatments. And you might wonder, okay, but how does this differ from the enduring guardian? The enduring guardian is the document in which you appoint someone to make those decisions for you, whereas the healthcare directive is the document where you list your preferences. So the healthcare directive and the enduring guardian couple nicely and would certainly instruct your guardian to know what to do if you couldn't make those decisions for yourself. I do hope that you've gathered some valuable information from this. So please reach out to Russ or Zoe if you had any additional questions that I might not be able to answer. Alternatively, you can make an appointment to come and see us at Dowson Turco.
Okay, thank you so much, Larissa. So we have a bit of time for some questions, Q&As and things. We can do this in a system where if people want to put in the chat if they have a specific question, then we can call out to them or I can read out the message. And I can unmute them and give them the opportunity to speak. Otherwise, we have a few questions that we can sort of go to, and Larissa can speak to as well, that we got in from everyone else. So potentially we'll give it a second, and if people want to put in the chat if they would like to answer or ask a question. We'll give it a couple of minutes.
I've got, I have one from Joe that asks, what is the definition of a de facto partner spouse?
So the Family Law Act actually provides a specific definition, but there are certain criteria that you have to show, and that could include financial dependency. They'll assess many different things when trying to determine whether or not you've been in a de facto relationship, the length of the relationship, all sorts of factors.
Right, thank you.
So I think maybe while we're waiting for other people to, if they want to say in the chat, I think we have a couple. So someone asked, can the enduring guardian and power of attorney be two different people? How can this operate, and are there any problems with this?
You can nominate whoever you'd like to be your enduring guardian and power of attorney. They do not have to be the same person. And we'd normally recommend that you have a substitute person in mind as well, in the event that your nominated attorney or guardian is unavailable or were to predecease you or just can't make those decisions.
And then we have another question that's just come in saying, is a funeral plan that is written by someone legally binding if it's not in the will? And how can we, I think that was a question that came up with a few people's messages in the pre-enrollment survey. So how can we make funeral plans legally binding, and what's the best way to secure those?
I would recommend discussing that with the person you've appointed as your executor. You could certainly attach your funeral plan to the will, but essentially it will depend on what your executor is able to pursue based on the information that they have available and the money that they have available to them.
I've got another question in, someone asking who they should contact at Dowson Turco, and I think that was another one that came up a bit. Maybe Larissa, if you could speak a bit to shedding light. I'm not sure about everyone else listening, but I know that kind of the thought of getting involved with a law firm and even taking those first steps can feel a bit foreign. So maybe
Certainly.
Larissa, if you could speak a little bit to what that process is. Say, if someone was joining this call for the first time and wanting to just sort of hear what the first step would be, what kind of cost would that look like? How would they even get involved with a lawyer to help talk to them about doing wills and things like that?
Of course. On our website, on the Dowson Turco Lawyers website, we have the ability for you to fill out, it's kind of like a questionnaire on what your wishes might be, who you'd like to nominate as your executors. You can fill out your personal information, and one of our friendly staff will reach out to you and give you an indication of when we could book you in for an appointment. An appointment will be $695. However, that initial appointment will come out of the total cost of your will. And our staff can send you an email enclosing our Protect package, which lays out the cost for the 3 separate documents, the will, power of attorney, and enduring guardian, and the discount potentially you'll receive if you do all 3 or just 2 of the 3, and what we would charge extra for or what might be out of scope. So all the information is in there, and you can have that prior to your first appointment.
Awesome, thank you.
Yeah,
So still,
one just to comment that we might be able to sort of open for discussion.
Yeah.
Corinne just makes the point, medical decisions often have financial implications, so the enduring guardian and the power of attorney are likely to need to coordinate to make some decisions together.
Yep. So in that instance, it would probably, if you had nominated the same person, it would be easier. But in the document, you can specify what the limitations of the person you've appointed with respect to making those decisions for you.
So I guess I'm just casting my mind back as well to the other the big overwhelming response, and I guess just for other people's information as well, that we got from everyone kind of in those in the enrollment surveys was
Mm-hmm.
that a lot of people there was a really big concern for our community about how to make sure chosen family and things are protected throughout all. And I know that you've talked to that, which is great. I guess, are there any key bits that you think people are maybe not aware of that, the common slip ups that people can kind of not be aware that their wishes could fall through the cracks? Are there any little, I's to be dotted or T's to be crossed that
Yeah,
people may not know?
of course. I think the The Succession Act is very disappointing in that the line of succession is blood relatives. And so if you do have a chosen family or a blended family, this is something which is not considered. So it is very important to stipulate who you'd want your estate to go to, and in the event that they're unable to, oh, sorry, Zoe, I think we've lost the
Oh,
point there. There you go.
does this worked again? So sorry.
That's all right. I think it's very important to have a will for that reason, to ensure that your wishes are met and that your money is being distributed the way that you want it to, and that people that you no longer speak to in your life are in fact excluded, or previous de facto partners, anyone who was perhaps taking advantage of you in the past, that you have considered that when you draft your will.
Is there a consideration, Larissa, for how often someone should update their will?
We recommend between 5 to 7 years, not because your circumstances change, which they may, but legislation also changes. So every 5 to 7 years would be a good idea to look at redoing it. You may come into more money, you may have sold assets, new partners. So much can happen in that time.
I've got another question in here as well. Who from Gary, who said, do you have contacts for referrals for people who are not in New South Wales? And I know you're obviously a New South Wales based organization, but I think that also raises a interesting point of how different things can be in different states. And I know Kylie will also talk to this a bit in her section, but could you chat a bit about that, Larissa, and maybe some considerations people should think about when, being aware that they're in different states, or does the law change much there in that example?
Yeah, that's a very good question. I'm not 100% sure, so that's something I would have to get back to you on, Zoe. We've accommodated people who've had assets in New South Wales, but also who have had assets in different states. So I'm not 100% sure. I definitely have to find out. The rules definitely change drastically, though, if the client has assets overseas, because then an overseas will definitely have to be considered in that jurisdiction.
Mm. I think it's a good lesson as well, like a lot of these answers, right? That a lot of things can change, and it's great that we're having this conversation and that these workshops are kind of available, that we can have that broad scope of things. But I guess it's a good point that all of us should be really making sure that we're checking what our individual circumstances are, right?
Yeah, definitely.
We do have another question that's come in as well, but just on that thought, I was going to ask, I know a few people in their survey responses mentioned maybe not having had contact with a law firm before, and how necessary is this? Do you need to get your will done by a professional lawyer, or what are some of those quick access routes for people, I guess, to make sure that it's legally binding?
Yeah. Unfortunately, there are many quick access routes, and I would not recommend them. I believe at Australia Post, they've got like a will kit that you can do. But as I mentioned, those copy paste templates they're just completely inadequate in protecting your assets, particularly because of how unique each person's circumstance is. So it's definitely best to get your will professionally done, to explain your whole story to the solicitor so that they can understand and provide advice tailored to your specific situation. And I would avoid those will generators or ChatGPT wills or whatever might seem like an easier option. I would avoid them.
Larissa, how important is it to kind of have the package of a will, a power of attorney, enduring guardianship. Is it necessary to have all three, or yeah, could you maybe just chat a bit to that sort of
Yeah,
space of like the necessity for all three?
of course. It's certainly recommended to have all three documents. However, the power of attorney and enduring guardian, they only become an issue when you become older and if mental capacity is something in question. So, if you are much younger and you don't have the money to do all three, I would certainly not be stressing about it tremendously. However, anything can happen in life, of course. And so, all three documents would be great to have as part of a very complete estate planning process.
I think from my experience of being with the community, because I have a lot of one-to-one time with the older community,
Mhm.
there's often a lot of fear, I think, around um, sort of disclosing information, maybe being open with who they
Of
are.
course. Yep.
Um, I guess with a queer law firm like yourself, it's
Yep.
easier. But is there any conversation around that? Because to encourage people to um, be
Yep.
open and make it as transparent as possible so the
Of
process is
course.
easy. Because I guess where I'm going with that is I hear some horror stories
I
with
can imagine.
what
Yeah.
happens with people when they die, and sort of partners have been together for a long, long time, and then one passes away, and then family sort of swoop in that
Yeah.
haven't been around. So yeah, it's just that
Mm,
sort of idea of disclosure
Yeah.
and openness.
mm,
Your will is a very personal, private, and confidential document. So while you're alive, you don't have to share your will with anyone unless you want to. And once you've passed away, only your executors are allowed to have a copy, unless it is, of course, requested, um, I don't know, by companies that want to ensure that they've distributed your assets accordingly, in which case just a snippet of the will be sent to them to say this person is in fact authorized to receive the share of this estate, for example.
mm, mm. We've got a couple more questions that have been sent in as well, which I'll ask, but I think one of them's actually just reminded me of one that someone submitted. Also talking about, you discussed mental capacity, Larissa, and how all of these things need to kind of be legally binding and signed off and done before you lose capacity. So, and Kylie, this might touch slightly on things that we'll address in this second workshop as well. But what sort of advice do you have about, say, the situation where someone, very young has an accident or something like that, and talking about guardianship and enduring guardianship and things?
Yeah.
What's the process if someone hasn't made those kind of steps? What's the sort of automatic thing, and how could that affect our queer community, and what does that look like? Is the answer just that we all need to get onto
Yeah.
things as soon as possible?
So if a guardian has not been appointed, you'll have to make an application to the New South Wales Civil and Administrative Tribunal. And if they are unable to appoint someone, if you didn't have a spouse or a living relative or a close friend, then they would have to appoint a public trustee. That would, of course, that person could hold their own beliefs. They could not be considerate of this community, and it would be so important to make sure that you finalize an enduring guardian before that happens
Mm,
in worst case scenario.
mm, mm. Oh, you're on mute, Ross, but it is a good one.
Of course I am. Yeah, no, it's a good one, an interesting one. and it came up when I did updated my will recently, but it's a huge responsibility for anyone to act as a enduring guardian or what's the other one? Power of attorney.
Mhm.
Requires strong competency and trust. It is difficult to find younger, in brackets, and capable friends or family to act as these. Any suggestions on how to resolve this? Because I know even when I was doing it, I was really made to sort of think about who might be the best people for these responsibilities.
Yeah, I completely understand that. That's certainly a difficult question to answer. It would depend on the individual circumstances of each person. But I would definitely discuss with the people that you do nominate what your wishes might be in those instances and how they can better support you. Maybe, you offer to be your friend's enduring guardian and they offer to be yours. Somehow you do some sort of rotation within the friend group, but
Mm,
unfortunately, that's very person specific. So,
yeah.
yeah.
I just wonder
Um,
if I could jump in there and
yeah,
just
please.
reinforce, and I think this is really important when we look at this in the scheme of doing an advanced care directive, because that really reinforces your values and preferences and any beliefs that you may have around medical treatment decisions, and can support a person in that substitute decision maker role, an enduring guardian around making health decisions if you don't have that capacity. So I think that is a way to support that person, really early, ongoing, really valuable conversations that explore what is important to you as a person, and to build that trust in that other person that they will act with your best wishes at hand. So I think that's a key part. And then we'll talk more about that next week, though.
It's a good teaser for what's to come, but yeah, that's really right. Thank you, Kylie. And we've got another question through as well. Someone said, if I have a healthcare directive and power of attorney, does that stop kind of being forced into public trustees or something like that? And maybe, yeah, can you talk a little bit to that as well, and kind of avoiding that system, and why people in our community might want to avoid that system a bit?
No, of course. Those documents certainly help avoid that additional control because you've nominated who you want to make those decisions for you. And if you did want any further information on that, that's definitely something that Dowson Turco lawyers would be able to assist with. We deal with these kinds of queries, particularly from the queer community. So, we are here to support you in making sure that your estate planning is finalized so that nobody is taking control where they shouldn't be taking control.
So we've got another one as well coming in. And thank you also, everyone, so much for sending these in. We probably have time for a few more questions, and then I'll pass us over to Kylie in a little bit as well. But to get through another one that we've been sent through. So someone here says, I'm married and have state superannuation scheme for my pension. The scheme has a system for transferring my proportion of my benefits until my husband dies. However, the Triple S will not permit me to inform them that we are legally married in Australia. And this might be slightly one that Larissa, you'd need to hear kind of the person's personal thing.
Yeah.
But yeah, it sounds like there's that sort of question of a lot of things, a lot of kind of bureaucratic things needing to be completely
Of
signed
course.
off and things. Um,
Yeah.
yeah,
Sometimes these issues can be quite complex. It's not one-dimensional. There's many different considerations and further questions to ask, but that's certainly the benefit of coming to talk to us about it because we will walk you through the process. But we do need a full picture of what's going on, understand the past a little bit better so that we can assist you in making the best decisions going forward with respect to your estate planning.
Mm. I think it's a great reminder, and yeah, this is kind of repeating similar to what we've said, but hearing all this information is a great reminder that all of our lives, and I think that's part of what makes our community so fantastic and unique, is that all of our lives and our chosen family and our situations do look different, and yeah, that kind of going to you and Dowson Turco or any other particular law firm that may speak to an individual is a good idea to really stay kind of informed and on top of these things, isn't it?
Yeah, definitely.
So maybe we'll just take the last question. And we've got one in saying, is the Public Trust Office a good backup for guardianship matters or not?
I think I can see Kylie smiling. I think it would depend, because you don't know what the person's beliefs are, and there's again so many different factors to consider. Personally, I would ensure that my estate planning documents were in place so that it doesn't get to that.
Mm.
Just a comment on that one. I'm currently on an advisory group with the trustee and guardianship board, and they're working towards making it more inclusive for everyone, which
That's
is a
hopeful.
good, yeah, it's a good move. So really understanding people living with disabilities, Aboriginal and Torres Strait Islander people, LGBTQ communities. So I think, yeah, I've been involved for about 12 months, and they are moving towards making it so when someone lands on the page and speaks to someone, that someone on the other end of the phone has a much broader kind of experience of what people in the community might be, how they might be living. So
Mm.
bit by bit, I think traditionally it hasn't been as easy to navigate, but hopefully they're moving towards making it a little bit easier.
That's good to know.
Okay, well, we and I think it's great that a few of these questions have kind of gone into the advanced care planning realm as well, which is a nice transition into. I might introduce Kylie now and let Kylie briefly chat about her work and kind of give us a teaser into what comes to our next week one. So thank you so much, Larissa, and if anyone also, like I mentioned, didn't quite get an opportunity for a burning question, we will be staying back a little bit if you did want to pick Larissa's brain a bit more. But until then, yeah, I might introduce you, Kylie, from Advanced Care Planning Australia. And yeah, do you want to tell us a little bit about your work and kind of give us a flavor of what to expect next week and how that links to this week?
Certainly. Thank you. Do you have the next slide at all? Pop that one
Yes.
through while you're
Yes,
doing that. So,
Mm.
yeah, thank you very much for that welcome tonight. And my name, as you said, is Kylie, and I use she, her pronouns. I'm the Advanced Care Planning Australia Education Coordinator, and I have a background in nursing. And that's in cancer and hematology, and really, I guess, gave me the background there around holistic person-led care, which I think is really, it aligns to this work that we're doing here tonight. So I would just like to thank the ACON team for the invite to collaborate with these workshops, and also acknowledge Dowson Turco team for their contribution tonight as well. And I think it's really laid that foundation for why it's so important for everyone to consider their futures across a range of areas, so financial, legal, personal, and health. And so, as I represent Advanced Care Planning Australia, we are a federally funded program operating as the national voice of advanced care planning. And we have activity across areas of education, community engagement, advocacy, research, and policy. And so, whilst you've covered areas of legal and financial planning tonight, the focus of advanced care planning is really your future health care. And I guess it really enables you to make some decisions now, so that if at the time around your health and personal care, so that if you were to become seriously ill and unable to communicate your preferences or make treatment decisions, advanced care planning really helps to ensure that your loved ones and your healthcare providers know what really matters most to you, and to respect those treatment and care preferences. And I think a theme that has come through some of the chats tonight is give you that control. I think that's very important, obviously. So next week, I'll provide a bit of an overview of what advanced care planning is and what it isn't. I'll also highlight what is involved in advanced care planning, so some of the document that you might want to complete. And as well, I haven't got the slide there in front of me, but really it's around thinking, talking to people, making your decisions and choices, and documenting those as well, and then reviewing them just as you would a will. Review that every 5 to 7 years. You'd go back and review your advanced care plans as well. So that is essentially what advanced care planning is. We also offer a national advisory line, but I'll put all that information in next week. And so it will be good to follow this up.
Awesome. Thank you so much, Kylie. So for everyone else's clarity as well, we are going to be kindly joined again by the exact same team. So Larissa from Dowson Turco will also be there because I think that this area has it is all tied in together. Obviously, any kind of advanced care planning, we also need to be aware of those legal aspects, and vice versa. Like we have probably all seen tonight, the most of our kind of legal questions also ties in with being aware of advanced care planning. So that's all to say, I think that these two workshops will link really well together. So it'll be great to have anyone who can joining us next week as well to chat a little bit more about this.
We have one other question, which I think is sort of important too, because I know when I was doing mine, I didn't want sort of religious affiliation anywhere, but Linda asks, I chose to not have any religious organizations involved in any of my future needs. How do I protect myself from them? I guess it's a big question, but it's sort of like, if you're not sort of led by sort of any religious belief, and you don't want that to be part of your end of life planning, can anyone sort of answer that question?
Yeah, certainly. I'll tackle that one. And it really comes down to what you are documenting within your advanced care directive and the values and preferences that you can express in there. And when we're talking about healthcare, it's not just around what happens medically when you're getting treated or managing a certain illness. We're really talking then holistically about your spiritual, cultural, your experiences that you value. And that's something that we'll actually explore next week, because coming to be able to very clearly communicate what those values and preferences around religion, what cultural needs you have, spirituality, what have you, is really important to be able to ensure that you do have that control at that point in time if you're not able to communicate your wishes, and tell your substitute decision maker, because they will also be your advocate to ensure that that care is appropriately put in place.
And Larissa, I think from my experience in doing my last will, I think I put something in my will that I didn't want any religious
I'm not allowed to disclose that.
funeral gathering. No, for me personally, I was sort of
Oh,
that was
you're wondering?
yeah, that was my choice to
Okay.
have that put in. Yeah. So at least it's sort of, if someone is reading the will and they've got that capacity to sort of design how I want to go out, It's in my will that I don't want any religious gathering.
Mm, mm. Yeah, and again, I think it really draws to the point that has been sort of drummed home for us as well of this is why it's so important to be making sure that it is all legally binding and to go to legal advice to get that because I think that question does also raise the really important point that when a lot of us go into aged care or go into kind of health systems and things like that, there is a lot of religious influence, whether you want that or not. So it's, yeah, I think it's a good reminder to make sure that everything is linked back. So thank you so much for saying that point. Yeah, Linda. So um, I've got another question come in, and we've got a couple more minutes until we'll close off. So we might just jump straight back into that Q&A section, just with the kind of disclaimer in the background. We'll pop there. But yeah, we've got another question come in from Julie saying, how long generally is it between someone dying and then someone reading the will? And that also could be an interesting point, Larissa, if you could maybe talk a bit, kind of shedding that light on what that process can look like. Because I think for a lot of us, that can just be this sort of mysterious element that we don't really know what happens until it does happen, right? So are you able to talk a bit about that to us now?
It can certainly be very quick from the time that someone dies to the request by the executor for a copy or the original will, sometimes within a day. Once the executor has a look at the will, they can then appoint a solicitor to assist with the grant of probate, which is the process whereby you apply to the court for grant of probate so that the deceased assets can be distributed in accordance with their will. Now, depending on the size of the estate and the complexity of their assets, or if they have vulnerable beneficiaries, generally, if everything goes to plan and there's no delays, then the court will take a few weeks to a few months to process that and for grant of probate to come through. However, if there is a claim on the estate by a family member who feels that perhaps they're entitled to a greater share or they weren't considered, then you could be looking at a couple months to potentially even a year or more. Again, it's situation dependent.
And if someone were to find themselves in a situation like that, like again, I think that could be something that maybe our community would face slightly more than other
Certainly.
people.
Yeah.
How would you suggest can they handle that without having their own lawyer if that's not something kind of financially available to them? Is it the sort of thing that to make sure that we don't kind of fall through those cracks and get those slippery kind of things tripping us up? Is actual legal representation necessary?
I think it would be, depending on the kind of dispute that comes along, it would be a good idea to discuss your options with the solicitor. Maybe you don't engage the lawyer for, every single step of the way, but they can perhaps provide you a letter of advice as to the next steps that you can take and what your chances of success are. Again, it would depend on the kind of dispute and who was trying to take claim of the estate. If it was an ex-spouse, or if it was a distant cousin whom you haven't spoken with in 20 years, it would be very different, and the advice would be tailored depending on the size of the dispute or issue.
Awesome, thank you. And then maybe our last question for the night is still to do with wills. We've got one asking, is probate required for all wills, or is it just for estates over a certain figure? And I think that also touches a bit on another few kind of recurring themes that we had, which is how necessary is all of this stuff if you don't have an estate of a certain size?
That's actually a very good question. Grant of probate is needed. I can't give you the exact number because each bank is different. So if you die and your only asset was $5,000 in a Westpac account, for example, then Westpac will more than likely not need a grant of probate from the court in order to give that money to your executors or whomever you decided is to receive your estate. Each bank has a different figure. It's normally around $50,000, but you'd have to inquire with your bank. It depends on the asset. Cars, jet skis, boats, those things could all be very different from monies in bank accounts. But to answer your question, no, grant of probate is not always needed, and it does depend on the size of your estate.
Awesome. Well, thank you so much, Larissa. And we are, that's pretty much taken us to the end of our time here. So again, we will be hanging back for a little bit. If someone wanted to, if they wanted to talk to us, had any questions or comments, just shoot a message in the chat and we can bring you in. But just to round it off, I'd like to thank everyone so much for coming in tonight and for engaging with ACON. First of all, to our wonderful hosts with me here. So Larissa and Kylie, but massive thanks to Larissa for answering all those questions and being so involved, and Brett as well from Dowson Turco. It's fantastic partnering with them. And yeah, Kylie, thank you so much for introducing yourself and jumping in there. I'm sure you will have all seen to our audience that this is one of two-part workshops. So no pressure to join for either one, but I'd like to think that if we're all here now, then we have that interest going. I for one am very excited about Kylie's workshop next week. So make sure to come along next week, and we're going to be kind of Kylie will be able to speak to this much more, but I think it's going to be a really nice workshop where we'll be able to really delve into things that Kylie touched on, thinking about our values and thinking about our preferences and things. So we're really excited to have you all again. And again, I touched on it at the start, but there's going to be the first of a few ACON things where we're going to be helping us talk about this death and dying space and becoming a bit more open to conversations with it. So thank you again. And thank you again, Beck, our interpreter, for joining us today. We really appreciate you coming. And Beck will be off now at 7 and won't be hanging around. But if anyone wanted to ask a question and have it answered, we can do something typing and things like that to help. So thank you everyone again for joining us. I hope you all have lovely evenings, and we will send out a survey evaluation, which will really help us to keep these going and see how we can improve next time and what things everyone liked best. So thank you very much. We will stay on here for a little while.